Okay. Good morning. My name is Ria, and I'm an intern at Thomas George and Associates. On behalf of Thomas George and Associate, I cordially welcome you all to the third National Virtual Moot Court Competition. We are pleased to extend a warm welcome to Advocate Meet Thakur and Varsha Raman for our judges for today. I will now proceed to explain the time division granted to each counsel in a single team. Each team will be allocated 30 minutes to present their case. Each speaker will be given 15 minutes unless otherwise is indicated by the team. Placard indicating time will be shown 3 minutes prior to the lapse of time allocated to the speaker, and once the time has elapsed. 30 seconds will be allocated for the rebuttals and the surrebuttals. We have team TGA 10 for representing petitioners, 17 representing the respondents. With the permission of our learned judge, we commence the preliminary rounds for the third National Virtual Moot Court competition.
Yes, please commence.
Okay. Petitioners counsel, you may proceed after confirming your preferred time division.
Right. Speaker 1, that is I, will take 17 minutes, and
17.
Speaker 2 will take 13 minutes.
Okay. Just a second, I'll just start the timer.
Right.
Right. You may begin in 2, 1.
Right. Good morning to everyone present here. Your Lordship, I hereby seek your permission to begin with my oral arguments.
Yeah, go on. You need not ask for permission every time you want to change over. Just keep going.
Right. Thank you. I'll begin with the facts of the present case, albeit in brief, thereby presenting my oral arguments. Your Lordship, the Republic of Parliamento is the country which is having largest democracy in the world, and people who are residing in Parliamento, they are from different economic, social backgrounds. And because of which everything was online, the economy of the Republic of Parliamento was on track. However, we were engulfed by a horrific pandemic titled to COVID-19 pandemic. And because of that, everywhere in the world, restrictions were imposed on the physical gatherings, and owing to which people were apprehensive to use physical currency for their day-to-day transactions. Because of which the importance or the need for digital transactions was realized. And at the same time, people started investing a lot in the virtual digital assets involving cryptocurrency at the same time. Because of the situations and the circumstances which were prevailing in the Republic of Parliamento, the government of Parliamento thought about imposing a tax of 30%, arbitrary taxation of 30% on all the virtual digital assets. This taxation is a uniform taxation of 30%, which is thereby imposed on all the virtual digital assets without making any sort of difference between the several attributes of virtual digital currency. The petitioners are contending that taxation on VDAs cannot be imposed in the absence of any law legalizing the transactions of the virtual digital assets. Your Lordship, the government of Parliamento had made an attempt to ban the virtual digital assets involving cryptocurrency. However, that ban was uplifted by the Supreme Court of Parliamento. Now, because the government of Parliamento thinks that they are not in favor of the usage of virtual digital assets, they have imposed taxation of 30%. When the citizens were informed of this decision of the government, they got perplexed as to when there is no law legalizing the entire framework, the taxation seems highly unjustified. Or on the other hand, should the petitioners assume because now the taxation has been imposed on the VDAs, the government has made an attempt to legalize all these transactions, there is a lot of ambiguity surrounding that aspect of it. As a measure, the citizens of Parliamento have filed a writ petition in the Supreme Court of Parliamento challenging the insertion of Section 115 BDH in the Income Tax Act of 1961, and the citizens are contending the validity of this section. Your Lordship, I'll begin with the issue 1, whether or not the government is justified in taxing virtual digital assets, which is still not legalized. And I will explain this issue. I will put forward my contentions by elaborating on 2 sub-issues within this issue. The first one being vague definition of virtual digital assets, and the second, provision of no set of losses for taxability. Lordship, it is humbly submitted before this court that the definition of VDA, virtual digital assets, provided in section 247A is vague and does not include the various attributes of VDA. Hence, taxing it under a single tax slab rate of 30% is highly arbitrary. It is contended on the behalf of the petitioners that the government is trying to define virtual digital assets and has consolidated all the attributes of blockchain like cryptocurrency and NFTs into the definition of virtual digital assets rather than defining them separately. This is vague and lacks clarity and is highly ambiguous. Lordship, in the last fourth line of the paragraph 5 of the Moot Court proposition, it has been mentioned, quote, while the government continues to contemplate its stance on cryptocurrencies and NFTs, it has in the interim implemented a new tax regime aimed at taxing gains and income from virtual digital assets at the rate of 30%. So it is very clear that the government is highly ambiguous and nebulous on the part of the legality or the illegality of the virtual digital assets, and it has imposed the taxation of 30% on all the virtual digital assets. The government has not made any significant difference between the two. Lordship, blockchain technology involves a data sharing and management system whereby individual data records are stored in blocks and then a chain-like structure is being given to them. And the blockchain technology is more secure than any other technology because of its complex framework of distributed ledger. And in order to hack a blockchain technology, you need to gain control over a wide arena of computers so that it is not easy for someone to hack the blockchain technology. Cryptocurrencies work on this technology, which is secured by a process called cryptography. Your Lordship, this is similar to the process of end-to-end encryption, which we see in the popular apps such as WhatsApp, whereby if any information is sent from the side of the sender, it will be received only by the receiver, and that information, particular information which exists in the form of blocks, that will not be accessible to any third party. Your Lordship, the nature of cryptocurrencies are fungible. Fungible, by meaning fungible, we mean that they are replaceable by another identical item. For instance, if I have 10 Ethereum in my digital wallet, that 10 Ethereum would be replaceable by another 10 Ethereum in someone else's digital wallet. So it is completely replaceable. It exists as an ideal mode of exchange method. And the entire process is very streamlined, thereby precluding any sort of governmental interference and any sort of international transfer fee. Your Lordship, in the case of NFTs, non-fungible tokens, they are unique digital assets. We use cryptocurrency to buy these non-fungible tokens. This can be understood from an analogy whereby we use the physical currency to buy certain physical objects in the real world. So there exists a substantial difference between the cryptocurrency, they are fungible in nature, and NFTs, they are non-fungible in nature. Anything which can be digitized and has a monetary value can be made into an NFT. It can be any GIF or JPEG or digital drawing, song, any video, so on and so forth. For instance, in the real world, Elon Musk had recently offered to sell his recent tweet as an NFT at a very high rate. And a few days back, Jake Dorsey had also sold his first tweet as a non-fungible token. And hereby we use the cryptocurrency as a mode of transaction to purchase these NFTs. So there exists a difference between the cryptocurrency and non-fungible tokens. Now let us understand the ambiguity surrounded under the section 247A of the income tax, whereby the government has tried, despite an unsuccessful attempt, the government has tried to define virtual digital assets. In the first point, it mentions any information, code, number, or token. Your Lordship, the same definition has been given in the paragraph 3 of the memorial. It mentions any information, code, number, or token. Now, there is no clarity what kind of token it is, whether it is a fungible token or a non-fungible token. Secondly, it is generated through cryptographic means. Both cryptocurrency and NFTs, they are generated through cryptographic means. So again, there is an ambiguity. It mentions providing a digital representation of value exchanged with or without consideration, with the promise or representation of having inherent value or functions as a store of value or a unit of account, including its use in any financial transaction or investment. And last but not the least, can be transferred, stored, or traded electronically. Both cryptocurrencies and NFTs can be traded and transferred electronically. Again, the government has failed to give any clarity on this aspect. Now, coming back to the section 115 BBH, under the clause A, subclause A of section 115 BBH, it mentions the amount of income tax calculated on the income from transfer of such VDAs at the rate of 30%. Your Lordship, the aspect or the scope of the word transfer is very wide. The government has used the word or the term transfer to include all sort of transactions, and this again generates ambiguity. So for instance, if I want to transfer 10 Ethereum from my one of the accounts to another account, will that also come under the heading of the word transfer? That has again generated a lot of ambiguity. Your Lordship, further, the central government is empowered to decide whether or not any virtual digital asset will be considered as a VDA under this section or not. Your Lordship, in the landmark case of Internet and Mobile Association of India versus the RBI, the Supreme Court had ruled to abhor any disproportionate restrictions on Indian cryptocurrency exchanges. This is explicitly evident because the Supreme Court had in this case set aside the measure which was taken by RBI to ban the cryptocurrency and all sort of virtual digital assets. Following that analogy here, because the government thought that it was not feasible to ban the cryptocurrency at the first place, they thought of imposing an arbitrary tax rate of 30% on the virtual digital assets without bringing any substantial differentia between the various attributes of VDA. And this is nothing more than a colorable exercise which is done by the government of Parliamento. Your Lordship, in the case of Internet Mobile Association of India versus RBI, the Supreme Court of Parliamento had held that, quote, virtual currency can have a unidirectional or bidirectional flow depending upon the scheme with which the entities come up. Therefore, different types of VCs require different treatments. Your Lordship, in the landmark case of Vodafone International Holding versus Union of India, the Supreme Court had held that, quote, it is well settled that the subject is not to be taxed without clear words for that purpose, and also that every act of parliament must be read according to the natural construction of its word. In a taxing act, one has to look merely at what is clearly said. There is no room for any intentment. There is no room for any equity about tax. There is no presumption as to tax. Nothing is to be read in, nothing is to be implied, unquote. So here the Supreme Court of Parliament had made an attempt that if the government wants to impose a tax or anything, the government should provide a clarity on what kind of tax it would be, and the tax rate should not be arbitrary. There is no room for any ambiguity which is there in the present case. Your Lordship, in the case of... Yes,
Counsel, one second. You've waxed eloquent about the fact that the definition is ambiguous and all of that, but
right.
Let's look at it from a very, sort of a close-cut view. We are essentially talking about different types of digital assets. These digital assets are all tradable, essentially. Right. They may be different in nature, they may have different attributes, but it is possible, nevertheless, to buy and sell these assets. So right. For the purposes of taxation, you have something that you're buying and selling, you're making an income out of it. And that income, the government is looking to tax that income. For the purposes of establishing whether something can be taxed or not, you have the component of an income, you have something that is saleable. Isn't that enough? What more do you want? Why do you say that each of these VDAs should be clearly defined and demarcated for the purposes of this act and for the purposes of taxation?
Right. Your Lordship, in the present case, there is no clarity as to whether these virtual digital assets are legalized. They are not legal tender. Many countries around the world have accepted that cryptocurrencies are a legal tender, but in Parliament, that is not the case. Right.
So highlight more on that and highlight as to why that makes the whole thing as a problem and not the fact that they haven't defined the different types of VDAs clearly.
Right. Your Lordship, in the case of Amit Bhargava versus Union of India, the Supreme Court had asked the government of Parliament to decide or to provide a clarity on the legality of cryptocurrency, and the government has failed to give any clarification on that, and that has been the case even at the present also. The government has not provided any clarity on the legality of the cryptocurrency transactions. Even if a law is there, we need the government to provide clarity, because there are various attributes of virtual digital assets. Definitely, you cannot come up with an argument saying that, okay, we are imposing a 30% tax rate on all the virtual digital assets. The scope and the ambit of virtual digital assets is very wide. We need to classify what kind of taxation will they impose on cryptocurrency, on non-fungible tokens, on various other attributes involving crypto mining. That clarity has not been provided by the government of Parliament in the present case. The Lordship, in the case of A.V. Fernandez versus the state of Kerala, the Supreme Court had held that quote, no tax can be imposed by inference or by analogy or by trying to probe into the interventions of the legislature and by considering what was the substance of the matter. Unquote. So again, here there is a lack of clarity. There is a high lack of clarity from the side of the government. In the absence of any law, again, I would say in the absence of any law legalizing the entire framework of virtual digital assets, so to say. Your Lordship, now I will proceed to the sub-issue 2 of the main issue, which is about the provision of no set of losses.
Before you start that, I have a question.
Right.
The definition is is clear that it is the tax is to be paid upon income from income generated from the transfers. So where is the ambiguity here?
That's what I also asked.
Right. Your Lordship, definitely the taxation, the income herein contain the transactions or the exchanges which will take place through virtual digital assets, the income there would be taxable. But again, I would say that there is no law legalizing the entire framework. There has to be an there's no room for any ambiguity, so to say. What we as the petitioners are contending, that the government should first of all provide clarity. There is an income, the income would be taxable. But again, the government has failed to provide any clarity. What kind of income would it be? For instance, I mentioned the concept of transfer. If I'm transferring my virtual digital assets or any kind of digital currency from my account only, from one of my bank accounts to another bank account, the government has failed to provide any clarity. What kind of taxation would it be? What kind of things or what kind of provisions they would include under the ambit of the transfer? And that is the entire starting point of the ambiguity surrounded by the section 115 BBH.
If the legislature, sorry, go ahead.
Ma'am, you please go ahead.
No, go on.
So if you transfer cryptos from one account to another, where is the income generated there?
Right, that is
generated. So you won't be liable for taxes.
Your Lordship,
under the concept of PAN card, it is possible to track. People will know both your bank accounts will be linked by the same PAN card. Right. So it is not possible. People will know that this is an inter-account transfer by the same person. So you're not going to be taxed on that transfer.
Right, Your Lordship. But that attempt has not been made by the government of Parliament. The government had tried to define the virtual digital assets under section 247A. But the government has not provided any clarity on that aspect of it. And that is why we say that section 115 is actually ambiguous on that part. I would like to start with the sub-issue 2 under issue 1, the provision of no set of losses for taxability. Your Lordship, there has been a provision under the section under the clause 2, subclause A, section 115 BBH. It reads that no deduction in respect of any expenditure or allowance or set off of any loss shall be allowed to the accessee under any provision of this Act in computing the income referred to in clause A. So, by the brief reading of section 115 BBH subclause B, no set of losses from transfer of the virtual digital assets computed under clause A of subsection 1 shall be allowed against income computed under any other provision of this Act to the accessee, and such loss shall not be allowed to be carried forward to the succeeding assessment years as well. So that means that if I have generated any loss in my income owing to the transfer of the virtual digital assets, I would have no time to recover those losses by adjusting those losses in with any other income, neither during the current financial year or nor during I can take that loss generated in the exchange of the VDAs in the next financial year too. And that again goes against that is again unconstitutional. My co-counsel would actually argue on the unconstitutionality of Section 115 BBH to provide more clarity on this aspect of it. So, Your Lordship, I would like to conclude my arguments. My co-counsel would argue on the issue too, whether or not Section 115 BBH is violative of the Constitution of Parliament too, and he would emphasize upon the aspect that Section 115 BBH is highly unconstitutional in nature, and thereby he would provide clarity on our prayer for today.
Thank you, Counsel.
Thank you so much.
Just confirming, the speaker 2 has 13 minutes, right?
Yes, he has 13 minutes. My co-counsel would be joining in 2 minutes. He's facing some issues over his device. So.
Ria, could I know that if the first speaker overshoots time, is it deducted from the second speaker's allotted time, or do they get their entire time and then see how much they've overshot?
I think it depends on your discretion. If you want to extend time, you can. However, it's advised not to. So if you want to include it within the time limit of the second speaker, we can do so.
Meet, what do you want to do?
I mean, you can decide as whatever.
We'll give them 13 and
Okay.
then but that shouldn't overshoot.
It should not be more than 13.
Yeah,
Like,
exactly.
no further extensions.
Yeah.
Speaker
Okay.
2, please note that.
Right, he's joining in a while. 1 minute.
If both of you are in the same room and if speaker 2 is having issues, just join through speaker 1's device. It's all right.
No, you're not audible, speaker 2.
Actually, my co-counsel is facing some issues over his laptop. Will it be okay if we can continue from my device?
Yeah, that's what I'm saying.
No problem.
It's not a problem.
That's what
Yeah, he's coming.
you can start when you are ready.
Lordship, I'm really sorry for that. I'm facing some technical issues. Can you please let me 1 minute? Just 1 minute, Your Lordship. I'll always be under your courtesy for that.
No problem.
You're audible. We can see you. What's the hold up?
Lordship, actually, I'm facing audibility problem. Can you please let me just a second, Your Lordship?
Okay.
I don't think you can give more than 5 minutes for technical difficulties. Okay, 10.
You all know the rules. What is your position regarding technical difficulties? It's 5 minutes. 0 to 10.
5 minutes, that's it.
Are you keeping?
I have
you
kept
set
time,
this-
it's done.
Okay. So we can then. Oh God, this is going to break everything up.
Ma'am, they are here, but they are not started yet.
I'm
This
ready.
is-
Speaker.
Yeah, please start. And please do not exceed your time. So be mindful of the fact that you have 13 minutes.
Yes,
Starting
yes.
in 3, 2, 1.
Greetings of the day. Greetings of the day from my side. I may please this is Divyan Sharma, appearing on the behalf of a petitioner in the case of XYZ versus Union of India. And I'll be dealing with the second issue pertaining to this case mentioned in the page number 11 to 13 of the Moot Court memorial submitted before this honorable court. Your Lordship, the council seeks permission to proceed with the second issue.
Yes,
Yeah,
yes,
you do
please go
need
on.
to see questions.
Yeah.
Much obliged, Your Lordship. The second issue before this honorable court is whether or not Section 115 BBH of Income Tax Act is violative of Constitution of India, which is very material to the Constitution of Parliament. To which I'll be dealing with the two sub issues. The first issue which has been raised in this regards is that the provisions of the Section 115 BBH is violative of Article 19(1)(g), Article 19 of
We can't hear you. One sec.
Constitution Parliament grants a power. Yes, yes, Your Lordship. The grants power to its citizen to have a right to trade in business. Also, at Article 19, 19 Clause 6 imposes a reasonable restriction on the exercise of the power in the interest of general public. It is humbly submitted before the honorable court that the taxation can be classified as a reasonable restriction in the exercise of power under the Article 19(1)(g). But it cannot be unreasonably. But the restriction cannot be unreasonably imposed. the decision of the government to impose a tax of 30% with no such right of set off of losses is unreasonably restricting the rights of the citizens of Parliament to who are indulging in the business of virtual digital assets. It is humbly submitted before the Honorable Court that high taxation of virtual digital asset actually impairing the business of a large number of citizens of the country who are involved in the business. So the decision cannot fall under the category of reasonable restriction under Article 19 Clause 6. I would like to draw the attention of the honorable court to the paragraph number 6 of the Moot Court proposition, which mentions that there is when there is no law legalizing the digital currency, the decision to tax which is such a high rate of 30% seems very unreasonable. The aspect of reasonability has been dealt by the honorable court in many instances and held that the government, if the government has to come up with an order or decree or order, it has to be reasonable in nature. I would like to draw the kind attention of this honorable court to the judgment of Union of India versus Hindustan Development Corporation, which held that where any government fails to satisfy the test of reasonableness and public interest and is found to want in the quality of reasonableness, it would be liable to struck down as invalid. And in this case, your lordship, the government has failed to make the standards of reasonableness by imposing 30% of tax to the virtual digital assets. I would like to let you know your lordship, that the 30% tax has been imposed on the business of money gained from wagering or money gained from in casinos like that. But virtual digital asset forms in a special part of business which does not fall into the category of those type of businesses. I would also
how is it different from buying and selling any other asset and making money out of it? Why should they be so specially treated when it's just another commodity that you're selling and buying and making money out?
Indeed, your lordship, but dealing in virtual digital assets has lots of involve lots of risk also, and it is subjected to various types of forces.
So even share markets, even dealing in the share market by purchase and selling of shares, also it's a risky business. You don't know when the market is going to plummet. It's exactly the same thing.
Indeed, your lordship. But what the thing is that the taxation of is that taxation actually impairs the business. It's not the reasonable restriction.
So according to you, if it is 30% is what makes it unreasonable. So if it is less, if it is 10%, 12%, you'll be okay with it. That's reasonable. That doesn't hamper business, correct?
To an extent, I think it is correct. But rather, I would like to draw your attention to the legality of it. Without legalizing it and taxing it at 30% rate of interest, actually makes it impossible for my client, which are the petitioner in this case, to carry out the business.
Talk more about why the absence of a governing legislation makes this unconstitutional, rather than saying that the rate of taxation is what makes it unreasonable. Get it?
Lordship, I'm actually not able to get your point because I'm facing some technical issues. Can you please repeat? It's very common.
Can you hear me now? Can you hear me clearly?
Yes, your lordship.
Yeah. So I'm saying, please emphasize more on the fact that in the absence of a governing legislation, it is what makes the whole thing unreasonable, rather than saying that it is the rate of taxation of 30% which is what makes it unreasonable. You yourself told me that it's not the rate of taxation, but the fact that there is no governing law. Correct?
Both aspects are there, your lordship. The rate of interest
so give me, quote some law that ties in the fact that in the absence of a governing law that governs the concept of VDAs, you cannot tax them. Give me the law to support that out.
actually, we are not going into the aspect of legality of the virtual digital assets, but we are arguing on the taxation of the virtual digital assets, as has been cited in the Moot Court memorial as well. Because lots of the legality will be decided by the government, and this honorable court has to deal with the question of legality if arises.
Go on.
Thank you very much, Lordship. I also would like to draw the kind attention of this court in that the case of Kasturi Lal, Kasturi Lal was the state of Jammu and Kashmir. Also, the landmark case, which has been cited in the paragraph number 7 of the Moot Court memorial, in which Justice Gajendra Gadkar, while pronouncing the judgment, held that the concept of reasonableness, right, non-arbitrariness, pervades the entire constitutional schemes and is golden thread which runs throughout the whole fabric of constitution. Also, in the case of Bhishma Dayal Chandra Mohan versus Union of India, cited in the paragraph, in the same paragraph, Justice Sen held that the expression reasonable restriction signifies the limitation imposed on a person in enjoyment of a right should not be arbitrary or any excessive nature. To end this issue, citing the proposition held by Justice Das in his dissenting opinion in the case of Behram Khurshid versus State of Bombay, which held that it is beyond all the dispute that if it is for the court to judge whether the restriction imposed by any existing law or any part thereof on the fundamental rights of the citizen are reasonable or unreasonable. Therefore, in the light of aforementioned facts and provisions of the law, it is ascertained that the provisions of Section 115 BBH of Income Tax violate Article 19(1)(g) and Article 19 Clause 6 of Constitution of Parliament. Your Lordship, if I have cleared all the issues regarding the first sub issue, the Council seeks permission to proceed with the second one.
Go on, please be mindful of your time limit.
Much obliged, Your Lordship. The second issue, the second sub issue which has been raised before this honorable court is that the Section 115 BBH violates Article 21 of Constitution of Parliament, which guarantees the right to livelihood. I may please to direct the kind attention of Your Lordship to the paragraph number 4 of the memorial, which says that due to the COVID-19 pandemic, the prevalence of virtual transaction has increased manifold. The inference can be drawn that due to the pandemic, when the people are struggling to make their livelihood, virtual digital assets come as a ray of hope for them to gain their livelihood. Government under Section 115 BBH of income tax provide for the taxation of income earned from the virtual digital assets, as it acts as a major impediment in the path of the carrying out the business of the virtual digital assets. As I would like to draw your attention of this honorable court that dealing with virtual digital asset involves lots of risk. So it is impossible for the people to engage in a business to carry out their business and act as a major impediment in the earning of their livelihood. The Constitution of Parliament has given utmost importance to the life and liberty of its people. This article covers wide range of rights within it. One of the most important aspects which has been incorporated in Article 21 is that the right to livelihood. Right to livelihood is one of the essential aspects which one for the survival of one's and value to which one not might get survive. So there are many instances when this court highlighted the importance of right to livelihood and held that Article 21, which talks about right to life and personal liberty, also encompasses right to livelihood. I would like to draw the kind attention of this honorable court, Your Lordship, that in the case of Ulga Telis versus Union of India, this honorable court held that the right to life covers the right to life. Court held that equally the equally important facet of the right to life is the right to livelihood, because no person can live without the means of living and the living of means of livelihood. if the right to livelihood is not treated as a part of constitutional right to life, the easiest way to deprive a person his right to life would be deprive him of livelihood to the point of abrogation. Also, this quote goes to the extent to say that deprive a person of his right to livelihood, and you shall have deprived him of life. Court in this case also held that any person who is deprived of his right to livelihood, except according to the just and fair process established by law, can challenge the deprivation as a offending to the right of life under
Counsel, how is this law infringing upon anybody's right of livelihood? It is not impinging on anybody's right to buy or sell or, transact in VDS. It just says that we will tax any income that comes from that. It's pretty, I mean, we don't live in a Gulf country, so I think that's pretty fair, isn't it?
Indeed, Your Lordship, I would like to thank you for raising this issue of utmost importance. I would like to answer this question by saying that the taxation, the heavy taxation, actually impairs actually bars the people indulged in this in the business of virtual digital assets to actually carry on their business. Because if you tax 30%, how can we expect a person to indulge in a business who earns 100 rupees, and you have to pay 30 rupees to the government as a taxation by taking a amount of risk which can goes to any extent. The value
Yeah,
of
if you're happy to do that when you're buying and selling shares, you should be happy to do that when you're buying and selling VDS. I don't
yes,
know why it's such a problem only with VDS that, oh my God, I cannot pay 30% tax. Why?
because yes, Your Lordship, thanks for raising this important point. I would like to answer that the dealing in stock and shares is a completely different aspect. There is a legal backing by the government. Also, in the case of the market falls, the government can give assistance, but this is not the case in the virtual digital currencies. Also, if you saw the taxation in the stocks and shares, it is of 15%, and in this case, it is of 30%. So these are the conflicting ideas. If you see, Your Lordship.
Okay, please wrap up. Your time's up. Thank you.
Yes, Your Lordship. I would like to also draw the attention of this quote. That's in the case of M.J. Shivani and others, state of Karnataka, the Justice K. Ramaswamy held a right to life under Article 21 does protect livelihood, but its deprivation cannot be extended too far or protected or stretched to the avocation.
Counsel, one second. Time's up. Pending confirmation from my co-judge, I don't think points of livelihood are relevant at this point. So
Even I don't think.
Yeah, so it's all right. You don't have to go on too much about the livelihood part. Just wrap up, please.
The council seeks permission to proceed with the prayer for the
Yes.
much obliged, Your Lordship. Therefore, in the light of above facts and provisions cited, it is submitted before the Honorable Court that Section 115 BBH of IT Act violate articles of the Constitution, and that's why are unconstitutional. Therefore, in the light of issues raised, argument advanced, and these reasons given and authorities cited, it is most humbly submitted before the Honorable Court to declare that the taxation of virtual digital asset is not justified. Also, to declare that Section 115 BBH of income tax is unconstitutional, and it violates Article 19(1)(g) and Article 21 of the Constitution of Parliament, and or pass any other order or direction that the Honorable Court may please to grant in the interest of justice, equity, and good conscience, all of which is respectfully submitted. And for this act of kindness, the petitioner duty bound shall ever.
What kind of writ do you want?
Can I have?
What kind of writ are you praying for?
We are praying for the writ of mandamus by this.
Okay. Thank you.
It's an honor to argue before your lordship.
Thank you.
Thank you.
The defendants can go ahead if you just tell me your time.
Greetings to everyone. I would like to confirm, am I audible properly?
You're audible.
Okay, thank you so much. Greetings to one and all present here.
Just a second.
from-
Sorry to interrupt. What is your time division? 15 minutes?
Yeah, I would like to explain that. We have a speaker one dealing with the first issue for 15 minutes, and the speaker two would be dealing with the second issue for 15 minutes.
Okay, I'll start in 3, 2, 1.
Okay. Greetings to one and all present, including the honorable judges. And speaker one, and I would like to seek the permission of your leadership and your lordship to grant us the permission to proceed with the facts of the case.
Yes,
I
please don't
think
keep asking for
the
permission.
fact,
Go on.
if
Okay.
Yeah, go on, Meet.
Okay.
I was saying,
Let's skip
we can
facts,
skip the
no?
facts as we are
Yeah.
already aware.
Okay, so I would direct start with the part of the argument.
Yeah.
Yeah. The first issue is whether the government is justified in taxing digital currencies, digital assets, NFTs, etc., which is not legalized. Right. In the argument, I'd like to start with the quote of Finance Minister Nirmala Sitharaman during the discussion of the Financial Bill 2022 in the Lok Sabha. She there mentioned that there's no confusing signal. We are very clear that there are consultations going on as to whether we want to regulate it or to regulate it to some extent, or very much, or totally ban it. After the consultants are concluded, the matter will come out, but till then we are taxing it as a lot of transactions are happening there. The government is not trying to put the unrecommended amount of tax on the cryptocurrency. They are basically trying to stop the hindrance of the money launderings and the corruptions. There are certain countries like the US considering cryptocurrencies to be properties, and tax gains derived from the transfers. The fair value for the purpose of determining such gains is the price at which the cryptocurrency was trading on the exchange when the transaction was completed. The decision to tax VDAs is not indicative of the legalization of the cryptocurrency or NFT in India. Basically, in the Republic of Parliament, asset required through the proceeds of crime and subject to tax. Similarly,
Sorry to interrupt you.
Yes,
Could you
ma'am.
please not read from your memorial? We'd like to hear arguments. I can read them. I've already read your memorial.
Sure. Indeed, you're right. The government has not legalized the cryptocurrency and the NFT and the digital assets, as the digital assets are performed in the blockchain system. Blockchain system is a peer-to-peer system in which one party can send to the another party, and it would be totally encrypted. No one no one would be able to interfere and know the records of the transactions. This will give a rise to the money launderings, the laundering of the money with the transaction of the big systems and with the big companies, and the companies with the black money would be able to transact it without the government being able to track it. The government has implied 30% tax on it as to rectify the chances of happening of any corruption in the process of the transactions of the digital assets. As it is an asset, and as it can be mentioned that anything that is an asset, anything that is an asset can be just give me a second. The Income Tax Act of 1961 under section 14 lays down the heads of incomes as the income of salary, house property, business of professions, capital gains, and income for other sources. So income from cryptocurrency can broadly be said to fall either under the head of profit and gains of business or profession, or under income of capital gains. So whatever that is.
Can taxation statutes be broadly interpreted? What do you think? Can you just say that, okay, this broadly falls within the definition of something? So how do you interpret taxation statutes? What is the threshold for interpreting taxation statutes?
Taxation is basically done on the basis of the income of a person. When a person,
I understand what taxation is, counsel.
Okay.
I'm saying, how do you interpret tax laws? What is the threshold to interpret tax laws? Is it okay to say that something broadly falls? It's all right, it almost nearly falls within this, so let's just take it as if it does. Is that how you interpret a taxation statute?
I apologize, Your Ladyship, I'm unable to get the question.
Okay, go on.
Yeah. So the classic conflict with the chargeability of an income under the head of capital gains, and the classic and the profits and gains of a business or profession in the nature in which the asset has been held, that it is to say if the asset is held as an investment or capital asset, then a charge under profit and gains of business or profession is leviable. At this juncture, it is to note the difference between the investment in the stock trade and the stock investment. So if it is a property or if it is a stock in trade, it is liable for the taxes. The taxes can be charged in the cryptocurrencies, in the NFTs and other digital assets, as it can be seen and it can be known that it is an asset and it is digital, not a currency. It's not a currency like RBI, the Reserve Bank of India, in Internet and Mobile Association of India versus Reserve Bank of India 2020. Supreme Court observed that it is not a cryptocurrency. It is a form of payment for the purchasing of goods and services, and it should be regulated by the RBI. It was tried to be banned in India, as it was observed about the unnecessary means of corruption done by the big companies on an aim of cryptocurrency, and that's why it was essential to bring the bill 115 BBH in the course of the implementing of the bill.
Counsel, I'm going to rephrase my earlier question. Okay.
Yes, ma'am.
The petitioner's main problem is that the VDAs and the different aspect of VDAs are not clearly defined, right? When you've been arguing all this while, you have been equating the concept of VDAs with things such as capital gains, with concepts that fall under the category of capital gains. But that's exactly where the problem is. VDAs by themselves are not being clearly defined. They're not demarcated clearly because there is no parental legislation that governs these assets. There's nothing that controls the transactions of these assets for you to say, okay, as a jump start, for you to say, okay, based on this law, which governs the concept of VDAs, here I'm coming and taxing any income that you may derive from them. Which then leads to the point that what does govern this? And which also leads me back to the point of interpretation of taxation statutes. Taxation statutes are strictly interpreted. There's no wiggle room to say that, okay, this almost falls within the category of something, so we shall take it as if it falls within the category of that thing. You can't do that in a taxation statute. It is strictly interpreted. So considering that, how do you think, I see a big loophole, big problem with this legislation, which also the petitioners have raised. So try and answer the questions and concerns raised by the petitioner in their arguments, rather than just, address whatever you thought was important. As a respondent, it's important that you address the petitioner's concerns.
Indeed, Your Ladyship. When it has been observed and in the period of pandemic, in the period of COVID-19, the demand and the investment in the cryptocurrency was at its peak. We have observed that the cryptocurrencies and all the other the digital assets, the digital transfers and currencies were at its peak in the investment. So people had already invested a lot. It wouldn't have been a good solution for the government to just eradicate the system of crypto from the country. But it has also been observed that the uses of the cryptocurrency was held in a malicious way. And that's why it was important to put a 30% tax. 30% tax somehow is a reasonable tax, because as we see wagering is also not legal in India. Actually, we have exceptions for wagering, but we put a 30% tax on wagering, the horse race. We put a 30% tax on that because due to the interest of people, it is not recommended and it is not possible for the government to just eradicate the system. But to control and handle the system, a government implied tax on the crypto system of India, of the Republic of the Parliament.
Also, your petitioner seemed to say that 30% was far too much, and they indicated that a lesser rate of taxation would be better. What are your thoughts on that? And if the court should hold that 30% is indeed a lot, would you be willing to go back and rewrite the laws to say that no, okay, we take the point from the court and we will reduce it to say 10%? You're still taking care of your, money laundering fears, because you are taxing something, so it is all regulated, but it's just the rate of taxation. Is that
indeed, Your Ladyship? We have also observed that the 30% tax, as our petitioners have filed, that the 30% tax is too much. But to understand that the necessity of the requirement for the bill. See, it can be seen that just okay, just give me a second. I'll have to eradicate the disturbance. Yeah, actually another moot session is also going on and we are in the same hall. So I apologize for the disturbance. Yeah, so the 30% tax cannot be concluded that it's too much. The government is still planning, as we have seen in the case of the Supreme Court of India and the RBI. It has been mentioned by the Supreme Court, and it has been given by the Supreme Court a suggestion to the RBI to work on the topic. The government is still working, and we understand that the working and the functionality of government is not at the perfection, but to maintain the system for the while we are conducting the research, while we are preparing a draft to bring a better system, 30% tax can be implied, as we have seen that cryptocurrency is not legal and it cannot be illegalized because many people have invested. So until we get a good system, a better system while we draft it, a 30% tax can be seen reasonable, as we have other illegal, not illegal, but not legal things we have putting 30% tax.
Council, is it the fault of people that invested that there was no legal framework for cryptocurrencies? Why should they be penalized at this point? Why should they be penalized? Because the government failed to make a proper law. So people that invested in cryptocurrencies when there wasn't a law should be taxed. This is like going back retrospective. You first should have had a law in place rather than going around banning things, right? Asking for things to be banned. You should have sat down, seen where the world is heading, and created a law that actually legalizes and provides a framework for this. On the basis of, then you can say you will tax. But now, in the absence of a legal framework, you can't say I want to tax. It's like having the cake and eating it too. You have to do your responsibility first as the government and then talk about taxation.
Indeed, Your Ladyship. We have seen that government, as I said earlier, that the government is still working on that. And the issue that we should have seen, and after the popularity increase of crypto, before the period of 2020, the popularity of crypto was very less in the Republic of Parliament. People were not much aware, and that is where the problem started. People were not much aware of the system of the cryptocurrency. Not every commoner was aware that the system is not legalized. What general and common people saw was a system where they invest and they get a good amount of money in exchange, in return. So this is where the consumer did not get the point, as they were not having the sufficient data about it. And as the government did not had
Why should an investor do background research about whether my government has legalized this or not before I can invest? You can't push the onus of knowing about this on the consumer. That's why there is a government. That's why the government takes up the responsibility.
Indeed, Your Lordship. I would have to say that the system is still trying to figure out a better way. We are still making a better drafting for it. Until the time comes, this is what we have implied. And I think I have given all the points I had. And I would now request the permission of Your Ladyship and Lordship, so that I can pass it to the speaker two, so that she can begin with the second issue.
Yeah, go on.
She can proceed.
Good morning, everyone. This is Speaker 2 here, and I would like to ask the council to begin with the arguments of the issue 2. I seek permission from the
Yes.
from the judges. So I would be dealing with the issue 2. Ma'am, do I have the permission?
Yes,
Yeah,
you can.
go on.
The issue 2 is whether or not Section 115 BBH of Income Tax Act is violative of the Constitution of India. So first of all, I would like to explain the Section 115 BBH of the Income Tax Act. It speaks about the taxation on cryptocurrencies. So it says that the proposed Section 115 BBH seeks to provide that where the total income of an assessee includes any income from transfer of any virtual digital asset, the income tax payable shall be aggregate of the amount of income tax calculated on income of transfer of any virtual digital asset at the rate of 30%. And I don't think that this is violative of the Constitution of India, because anywhere in the Constitution of India, it is not mentioned that the 30% tax or the taxation of cryptocurrencies is not is violative against it. And
Is there a problem, council?
ma'am, am I audible?
Yes, you are.
So sorry, ma'am. The Cryptocurrencies and Regulation of Official Digital Currency Bill, that is of 2021, is currently being considered by the Indian government. The new bill aims to outlaw private cryptocurrencies in India with a few exceptions, promote cryptocurrency trade and its underlying technology while facilitating the development of an official digital currency that will be issued by the RBI. Now,
Council, please don't read from the memo. Please argue.
But it is not it is illegal. There's something that is
Can you hear me?
Is there any problem with the device?
ma'am, it's lagging.
I'm going to put it in the chat box if not.
Can I rejoin?
Ria, is there a way of letting her in again if she wants to exit and re-enter?
Yes, ma'am. Should I pause the timer?
Yes, please.
Yes.
You can rejoin.
Ria, if you have a contact number, just try giving her a call and seeing what's the matter.
Yes,
And
ma'am.
how
I'll
long it's been.
contact those. Yeah.
Ma'am, am I audible?
Yes.
I'm really sorry to the lord, to your lordship and ladyship for the inconvenience. Can I continue again?
Yeah, that's okay. Just please don't read from your memo. Please present your arguments.
Sure, ma'am. Sure. So I was dealing with the section 115 BBH of the Income Tax Act that talks about the taxation policies on the cryptocurrency, and the bill seeks to tax income arising on transfer of virtual digital assets at the rate of 30%. That 30% rate, as of today, we know that a tax of 30% is also levied on income from sources such as winning from lotteries, betting, horse races, etc. This somewhere indicates that the ministry is viewing income from cryptocurrencies with the same lens as other incomes, that is wagering and all. Considering that individuals have an income exceeding that 1 million are anyways taxed at 30% today, the proposed tax rate of 30% may not be viewed negatively by the industry. And this says that the tax levied is not violative against the Constitution of India, as it is also not mentioned there. And while some people may think that the imposition of tax on VDS makes them legal, the jurisprudence on direct taxation suggests that the contrary, as under the income tax law, even an income arising out of unlawful businesses is subject to taxation. In the case of, ma'am, there is this case of CIT versus Thangamani, which says the Honorable Madras High Court observed that income tax authorities are only concerned about the income and not about the mode and means of acquiring it. There is also the one case that is the case of Honorable Gujarat High Court which has allowed deduction on the income generated from a smuggler's confiscated gold as it accounted for loss in his business. Your ladyship, I would really like to apologize that I have technical issues. Ma'am, is there any
Why
cross
don't you use
questions?
the same device as your co-counsel? He wasn't having any issues, right? Are you on
Ma'am,
the same device?
Ma'am, we are using the same device, but now there's some technical issues relating to it. Ma'am, I would like to conclude it.
Okay.
Ma'am, is there any cross questions regarding to it?
No, go on. Meet, do you have any questions?
No, I don't have any questions. She can proceed.
I seek the permission for the prayer from your lordship and ladyship.
Yes, please.
I pray that in the light of legal precedents and principles cited, and in the light of provision of the Constitution applied and arguments advanced, and in the light of scientific studies relating to the issue report to the petitioner, most humbly prayers that the Honorable Supreme Court should hold that the SLP is not maintainable, hold that the right amount of tax cannot be levied on the digital currency, and BDAs not uphold the right to pay no more than the correct amount of tax, not adjust that the sections 115 BBH Income Tax Act 1961 are ultra-fires, and pass any other order that it may deem in the ends of the justice, equity, and good conscience, all of which is respectfully submitted.
Just say that the SLP should be dismissed. Finished. Nothing else.
Sorry, ma'am.
Just pray for the petition to be dismissed. That's all you need to do as a respondent. You don't have to go into all of this. Also, your second point, you want us to hold that the right amount of tax can't be levied on VDS. It's entirely the petitioner's case. Anyway, thank you very much, counsel.
Thank you, counsel.
Thank you so much, Honorable.
Participants, you are not allowed to, rebuttals. The petitioners, you can go for the rebuttals. You have 30 seconds.
Right. So I'd like to proceed. Speaker one from the respondent side mentioned in his speech that there's no sufficient data. People started using VDAs a lot, and suddenly they came up with the thought of imposing 30% arbitrary tax on the virtual digital assets. Our contention is that why you have not came up with the law by using the reasonable restrictions underlined under Article 19 Clause 2 of the Constitution of Parliament, with the sufficient data, as you said. You should come up with a law with, with the sufficient data in 19.2. But in the absence of a law, you have come up with a move to impose tax, which goes against the very spirit of the Constitution. So why there was the absence of law, and the respondent were not able to justify as to why 30% tax was still justified. Thank you.
The respondents, you can go ahead. You're on mute. No, you're not audible. Judges, they are having a technical issues. This is fine to give them 2 minutes.
Okay.
Yes.
You'll have to do it quickly though. Judges, they won't be doing the cerebrals. Is that fine?
Yeah, I mean, what can you do?
Okay. Okay, then that's how we conclude the competition. The judges are requested to give a feedback from the OC. The participants, after leaving the meet, you cannot go to another room and participate or be an audience or view others' competitions. You just have to leave the meet completely. The judges can give the feedback now. Also, the judges are supposed to send the score sheet to the Moot email ID after filling them. Is that
It's a
fine?
Google document, no? Even if I just close it, you all should be able to access. Or do we have to send it back to you?
No,
We
it
have
is
to
a Word
request.
document, I guess.
I've been sent a Google Sheet.
Oh, just a second. I'll just request. I'll just ask for him. You can continue with the feedback. I'll get back to you.
Okay. Meet, you want to go first?
Ma'am, please go ahead.
Okay, in general, for everybody, common feedback for everybody. Please don't get flustered when judges ask you questions. That's what we are here for. And always account for some time. Don't, if you have 17 minutes as your speaking time, do not plan to speak for 17 minutes. Plan to speak for 15 minutes. Give some wiggle room for judges' questions, time that you take to understand the judges' questions, answer them. Also, when we ask some question, it's okay for you to take about 3 to 4 seconds to sort of process what's being asked. You don't have to start rattling away the answer right after we ask the question, because more often than not, if you start talking the moment we finish the question, we're not going to get the answer we're asking for, right? Or you may not even end up coming close to answering the question we actually asked. Also, be prepared for all of this. When you do your research, try and research. Obviously, you're researching from both sides of the problem. So try and anticipate questions. When you're thinking from the petitioner's side, try and anticipate what questions can the respondent raise. What sort of tricky areas are there? What are the gray areas that you need to know the answers to navigate for? Obviously, there are gray areas. That's the hallmark of a good moot problem, that there's no clear-cut answer for every question that's being raised. Your attempt is to come as close as possible to giving us a convincing answer from your side, right? Specifically speaking now, team 10, speaker 1, when you mention the statement of facts, your facts are supposed to be very, you're not supposed to take sides while presenting the statement of facts. You mentioned the word arbitrarily. The government is arbitrarily taxed at 30%. Whether it is arbitrary or not, we will establish after you've finished all of your arguments. And during the course of your arguments, you will say, you will present, or you will try and convince us how it's arbitrary. You don't mention that in the statement of facts, okay? And we tried to lead you, both my co-judge and I tried to lead you into, talking more about how the absence of a parental legislation is the problem here, rather than the rate of taxation or the definition of different types of VDAs. But both teams stuck on to that, obstinately stuck on to that point of, that VDAs have not been defined clearly. and how the rate of taxation is okay, which is why I also led you into it. I led you into a trap and you fell right into it. I also asked you, are you okay if the taxation rate is reduced, but the taxation is kept as is? And you said, yes, no problem. You or your co-speaker, I forget who exactly. But things like this, traps like this, you need to avoid. So that's why I'm saying be mindful of what the judge is asking, try and understand the question before you answer. Yeah, and speaker 2, team 10, essentially told me what my job is as the judge and what the court is supposed to decide. And that the question that I asked apparently is not within the ambit of my job as the judge and not within the ambit of the authority of the court. Please do not make such statements before real courts. I laughed it off. I guarantee you judges will not do that in real life. So be mindful of things like that, and always, like I said, time yourselves and leave some wiggle room, leave some leeway for judges' questions. That's about it from my end.
Same feedback. The only addition would be that be confident. You know, when you answer questions, there was some lack of confidence while you were answering, and the answers were not connected to the questions. So from next time, try to anticipate what questions would be asked and be confident about your answers. That's it. Otherwise, it was a great job on both the sides.
Well done, everybody. There's always learning grounds and takeaways from every competition. I hope you all had as much fun presenting as we did judging, and good luck for the next rounds.